With yours in the presence of the court, to see the jury box.
You may have a seat. Good morning, everyone. Welcome back. As I indicated to you, every morning we begin with the same questions. Did anyone become aware of any of the facts of the case, do an investigation on your own, or have somebody approach and tell you anything about the case? No. All right, thank you so much. Ladies and gentlemen of the jury, you have been selected and sworn as a jury to try the case of State of Florida versus Luis Toledo. This is a criminal case, and Mr. Toledo is charged with first-degree murder with regards to the death of Michael Otto in count 1 of the indictment, first-degree murder with regards to the death of Thalia Otto in count 2 of the indictment, second-degree murder with regards to the death of Yessenia Suarez in count 3 of the indictment, and tampering with physical evidence in count 4 of the indictment. The definition of the elements of first and second-degree murder, as well as tampering with physical evidence, will be explained to you later. It is your solemn responsibility to determine if the state has proved its accusations beyond a reasonable doubt against Mr. Toledo. Your verdict must be based solely on the evidence or the lack of evidence and the law. As I have said to you before, the indictment is not evidence, and it is not to be considered by you as any proof of guilt. Now, it is the judge's responsibility to decide which laws apply to this case and then to explain those laws to you. It is your responsibility to decide what the facts of the case may be and then to apply the law to those facts. Thus, the province of the jury and the province of the court are well defined. They do not overlap. This is one of the fundamental principles of our system of justice. Before proceeding further, it might be helpful for you to understand how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make what is called an opening statement. The opening statement gives the attorney a chance to tell you what evidence they believe will be presented during the trial. Now, what the lawyers say is not evidence, and you are not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits also may be produced as evidence. After the evidence has been presented, the attorneys will have an opportunity to make what are called final arguments. Following the arguments by the attorneys, the court will instruct you on the law applicable to this case. After the instructions are given to you, then and only then you will retire to consider your verdict. Now, you should not form any definite or fixed opinion on the merits of the case until you have heard all of the evidence, the argument of the lawyers, and the instructions of the law by the court. Until that time, you should not discuss this case among yourselves or with anyone. During the course of the trial, the court will take recess, during which you will be permitted to separate and go about your personal affairs. During recess, you will not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about the case, tell them that you are on the jury trying the case and ask them to stop. If they persist, leave them at once and immediately report the matter to the bailiff, who will then advise me. Now, this case must be tried by you only on the evidence presented during the trial in your presence and in the presence of the defendant, the attorneys, and the judge. Yours must not conduct any investigation of their own. Accordingly, you must not visit any of the places described in the evidence. You must not read nor listen to any reports about this case. Further, you must not discuss this case with any person, and you must not speak with the attorneys, the witnesses, or the defendant about any subject until your deliberations are finished. In every criminal proceeding, the defendant has the absolute right to remain silent. At no time is it the duty of the defendant to prove his innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt, and the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. Now, the attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had the witness been permitted to answer the question. Now, if you would like to take notes during the trial, you may do so. On the other hand, of course, you are not required to take notes if you don't want to. That will be left up to you individually. You have been provided with a notepad and a pen for use if you wish to take notes. Any notes that you take will be for your own personal use. However, you should not take them with you from the courtroom. During recess, the bailiff will ask you to leave your notes face down in your chair while we take a break. When you return from the recess, you'll find your notes waiting for you right in your chair. After you have completed your deliberations, the bailiff will deliver your notes to me. They will be destroyed, and no one will ever get to read your notes. If you do take notes, do not get so involved in note-taking that you become distracted from the proceedings. Your notes should be used only as an aid to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of another juror. Notes are not entitled to any greater weight than each juror's memory of the evidence. At this time, I would ask, does the state have any witnesses present?
Only one, Judge.
Okay, is the intent of the court to invoke the rule?
Oh, wait a minute. Excellent, Judge. Judge, before we just briefly quote on this matter.
Yes, sir.